An executive order just put millions of mail-in ballots at risk. With one signature, restrictions on absentee voting could disenfranchise voters across America. Now the NAACP and civil rights groups are fighting back in federal court. This case could reshape how Americans vote forever. Welcome to Court Decoded. Today we cover the explosive lawsuit challenging executive authority over mail-in voting and the constitutional battle that could define election rights for a generation. In early 2025, an executive order emerged from the White House that sent shockwaves through voting rights communities nationwide. The order, targeting mail-in ballot procedures, directed federal agencies to implement new restrictions on absentee voting, a method used by tens of millions of Americans in every election cycle. The stated justification centered on election integrity and preventing fraud. But critics immediately recognized something far more consequential. Mail-in voting has historically been essential for specific populations: elderly voters, disabled Americans, military personnel stationed overseas, and working-class citizens who cannot take time off to wait in polling lines. Within hours of the order's announcement, civil rights attorneys began drafting legal challenges. The question at the heart of this battle is deceptively simple but constitutionally profound. Does a president have the authority to restrict how American citizens cast their ballots? To understand what is truly at stake, consider who relies on mail-in voting most heavily. Rural voters in states like Montana and Alaska, where polling stations can be hours away. Shift workers who cannot leave their jobs on a Tuesday. Elderly Americans with mobility challenges. Military service members deployed to bases around the world. The restrictions outlined in the executive order would create new identification requirements, limit ballot return timeframes, and impose federal oversight on what has traditionally been a state-controlled process. Civil rights organizations quickly documented the potential impact. Communities of color, which already face documented barriers to voting, would be disproportionately affected. Studies consistently show that minority voters use mail-in options at significant rates, particularly in states with histories of polling place closures in minority neighborhoods. This is not abstract policy. This is about whether millions of eligible Americans can exercise their constitutional right. The National Association for the Advancement of Colored People did not hesitate. Within days, the organization filed a federal lawsuit challenging the executive order, joined by a coalition of civil rights groups with decades of voting rights litigation experience. Their legal strategy attacks the order on multiple constitutional fronts. First, the Elections Clause argument. Article 1, Section 4 of the Constitution explicitly grants state legislatures the power to determine the time, place, and manner of elections. While Congress has some authority to override state regulations, the President, acting alone through executive order, may have no such power at all. Second, the Voting Rights Act claims, though weakened by the Supreme Court's 2013 Shelby County decision, remaining provisions still prohibit practices that result in discrimination based on race. The plaintiffs argue these restrictions would have exactly that effect. Third, the Equal Protection Clause under the 14th Amendment, which requires that all citizens receive equal treatment under the law. The constitutional questions in this case go far beyond mail-in ballots. At its core, this lawsuit asks federal courts to define the limits of executive power over elections. The Constitution's framers deliberately distributed election authority across multiple branches and levels of government. States run their own elections. Congress can pass election laws. The courts interpret constitutional protections. But nowhere does the Constitution explicitly grant the president direct authority over voting procedures. Executive orders carry the force of law, but only within the bounds of existing constitutional and statutory authority. When presidents overstep, courts have historically struck down those orders. The famous Youngstown Sheet and Tube case established the framework courts still use today. Presidential power is at its lowest when acting against congressional intent or constitutional structure. Here the NAACP argues, the president has ventured into territory the Constitution reserves exclusively for other actors. This case arrives against a backdrop of decades-long battles over voting access. The Voting Rights Act of 1965 dismantled Jim Crow restrictions that had prevented Black Americans from voting across the South. For 50 years, it required states with histories of discrimination to obtain federal approval before changing voting laws. That pre-clearance requirement was gutted in 2013's Shelby County decision. In the years since, states have passed hundreds of new voting restrictions, voter ID requirements, purging of voter rolls, closures of polling places in minority neighborhoods. Civil rights groups argue mail-in voting became increasingly essential, precisely because in-person voting became harder for many communities. Limiting mail-in access, they contend, does not occur in a vacuum. It occurs in an America where other voting options have already been restricted. The pattern, they argue, reveals discriminatory intent even if the words of the executive order appear neutral. The administration's defense rests on several arguments. First, presidential authority over executive agencies means the president can direct how federal officials interact with state election systems, particularly where federal funding or oversight is involved. Second, election integrity concerns provide legitimate government interest. The administration points to examples of mail-in ballot problems, though studies consistently show voter fraud is extremely rare. Third, the government argues that the order does not ban mail-in voting, it merely adds safeguards. Courts, however, have historically been skeptical of restrictions that make voting more difficult, while claiming not to eliminate it. The legal principle is clear. Even regulations that do not outright prohibit voting can still violate the Constitution if they impose undue burdens on the right to vote. The question becomes whether added safeguards cross that constitutional line. Federal judges now face a profound question about the architecture of American democracy. The immediate issue is whether to grant an injunction blocking the executive order while litigation proceeds. Courts apply a four-factor test: likelihood of success on the merits, irreparable harm, balance of equities, and public interest. For voting rights cases, irreparable harm is often presumed. Once an election passes, there is no remedy for those who could not vote. But the deeper constitutional questions will take months or years to fully resolve. Does executive authority over federal agencies extend to controlling state election procedures? Does the Elections Clause create an impenetrable barrier against presidential interference? Do remaining Voting Rights Act provisions prohibit restrictions that disproportionately affect minority voters? And perhaps most fundamentally, in the constitutional structure, who gets to decide how Americans cast their ballots? Whatever the courts decide, this case will establish precedent affecting every future election. If the executive order stands, presidents will have new authority to shape voting procedures nationwide, regardless of what state legislatures prefer. If the order falls, clear limits on presidential election authority will be reinforced for generations. But the implications extend beyond voting. This case tests the broader boundaries of executive power in an era of increasing polarization. It asks whether courts will enforce structural constitutional limits when political stakes are highest. Civil rights organizations view this as a defining moment. Decades of voting rights gains could be rolled back or reinforced depending on the outcome. The NAACP has framed this explicitly as a continuation of the long civil rights struggle. The same fight, they argue, that their organization has waged since 1909. This case remains in active litigation, with initial court rulings expected in the coming months. The outcome will likely reach the Supreme Court, where the current composition of justices will determine the constitutional boundaries of executive authority over elections. What is already clear is the legal lesson this case teaches. The Constitution deliberately fragments power over elections, and any attempt by one branch to consolidate that authority faces significant constitutional obstacles. The right to vote is fundamental, and any restrictions on that right, regardless of their stated purpose, will face intense judicial scrutiny. The NAACP's lawsuit represents more than a policy disagreement. It is a constitutional test of whether structural protections can withstand political pressure. Whatever the final verdict, this case will define voting rights for the next generation of Americans. If you found this constitutional battle fascinating, hit subscribe and the notification bell. Court Decoded breaks down the legal cases shaping America every week. Drop your thoughts on this case in the comments below.